People will often ask me, can I wipe out a judgment debt in my bankruptcy case? A judgment has two aspects to it. First, it's a determination that you have personal liability to pay a debt. Second, whenever a creditor gets a judgment against you, it becomes a lien on any real estate that you own. Now, as far as wiping out your personal liability to pay a debt that's based on a judgment, you can do that as long as the underlying debt can be wiped out in your bankruptcy case. In other words, you can't wipe out your liability to pay a student loan. So if a student loan creditor obtains a judgment against you, you can't wipe that out in your bankruptcy case. Now, on the other hand, if the judgment creditor is a credit card company, you can wipe out that type of debt in a bankruptcy case, so you can wipe out your personal liability on that judgment by filing bankruptcy. Now, the second issue becomes, can you wipe out the lien that's on your real estate by filing bankruptcy? Now, in certain situations, you can wipe out that judgment lien. In other words, if you can exempt or protect the amount of equity in that property, then you can wipe out the judgment lien. For example, if you have less than $35,000 of equity in your residence and a creditor obtains a judgment against you, then in your bankruptcy case, that judgment lien can be voided or wiped out. On the other hand, if you have more than $35,000 of equity in your residence and you file bankruptcy, you might not be able to wipe out the judgment lien because you have more than $35,000 of equity in your residence and you can't exempt all of that equity. But in most cases, when people file Chapter 7 or Chapter 13, not only do they wipe out their personal liability to pay the judgment, but they're also able to wipe out the judgment lien against their property.